Today we'll be dealing specifically with the will, so stick around. I'm Seraphia Spence, founder of Wealthitude, wealth and business coach, and a practicing attorney here in Jamaica. So, Observer, I saw the article online earlier today. I think it was about a day old. And this had to do with Delroy Chuck and him urging Jamaicans to make wills. And he cited that 55 billion in undistributed assets. Yes, I did say 55 billion with a B. Let that sink in. Now, and I'm going to read his quote. It says, at the moment, persons who have not made a will have caused a burden on the Administrator General. They have in excess of 50 billion worth of property that they would like to distribute amongst beneficiaries. And because they are fighting or cannot agree, that is filled up by the Administrator General. So, this is some real figures that we're looking at, and real assets that people have worked very, very hard for, which I'm sure, for the most part, some of them would have intended to have gone to their beneficiaries. Let's pause for a moment and think about what that means. Having read the article and understanding as an attorney the implications of someone dying intestate or without a will, I felt the urge to make this video for our community to ensure that you understand what those implications are and that you are now equipped with the knowledge to be able to make a better decision in putting your estate or your affairs in order. So now that you've heard and seen the minister's article, first off, before we get into anything else, let's start at what is a will. And quite simply, a will is a legal document where you say what you want to happen to your money, your property, any asset, any personal asset that you may have after you die. So, through the will, you can name beneficiaries, pick a guardian for your child if you have children, and also appoint an executor to carry out your wishes on your behalf. If you don't make a will, then when you die, you will die intestate, and the law will therefore decide what happens to your estate, what happens to all of the things you've worked for, and how much of that your family gets. Section 6 of the Wills Act outlines the requirements for a will that are quite simple. And the will outlines the testator's intentions and execution procedure. So the main points that you look at in a will include things like the testator's capacity and the individual creating the will, which is the testator, must be of sound mind, and that person must be acting voluntarily and have the legal capacity. Must not be a minor, must be over 18 to make those decisions about their estate. Now, there's also a requirement for the will to be in writing. The will must be in writing. And this includes whether or not you're going to write it, handwrite it down on a piece of paper, or you're going to type it up. It must be in writing. The will must also be witnessed. It must be witnessed by at least two individuals. And these individuals must not get any benefit. They must not be any get must not be beneficiaries under the will. And the witnesses, there's also a further requirement that the witnesses should see the testator sign and acknowledge their signatures in their presence. And they must be present both at the same time. And the witness and the testator must sign the same documents. There's a further requirement under Section 6 for a date to be attached to the will to say when the will was executed. And let me say this, no oral wills will be made or recognized. If you do not have a will, as I said before, you die, you're considered to have died intestate. And you are then unable to say who gets what at that particular time when you die. As you know, dead man tell no tale. You are silenced. There's no more you telling anyone what to do with what belongs to you. And I want that to sink in. Now, Section 6 of the Wills Act is what deals with or outlines the requirements of a valid will, and it emphasizes the testator's intentions and execution procedure. Now, the testator is the person that is writing the will. That's how the law recognizes them, as the testator. And the law says that somebody writing the will must have the capacity, and the capacity doesn't only have to deal with age, so they must be over 18 years old, but also they must have the mental capability or mental capacity to be able to write that will. And the will must be done voluntarily. You can't force somebody to give you nothing in the will. It is something that they will have to decide on their own. They will have to decide what happens to their estate and set it in writing. So the everything that you have worked for, if tomorrow never comes, we get Estates and Property Charges Act, and this governs the distribution of that person's estate. So I want to ask you, and we're going to be looking at what's the real cost of your silence? What's the real cost when you do not take the time to make a will or put some plans in place for the distribution of your assets when you're no longer here? I want to ask you a few questions. So, what happens if, so I want to ask you a few questions. Never comes. We get up every day and we think, oh, tomorrow I'll do that. Next week I'll do that. But truly, when you do not make a will, you put a stranger in charge of your assets and your beneficiaries. So think about it. When someone dies, and the Intestate Estates and Property Charges Act kicks in, then the law has set out a table of distribution highlighting how those assets are actually distributed. I'm going to share them with you. So, where someone died leaving children, parents, spouses, and so forth, this is how the law looks at it. First and foremost, I'm going to look at spouse, children, and parents. So if someone dies leaving a spouse, children, and parents, then the law indicates that half of the assets go to the spouse, half to the children in equal shares, and if there's only one child, then 2/3 goes to the spouse and 1/3 to the child. In this particular distribution, then the parents do not get a share in the estate. Where someone dies and there are children and parents only, then the children take all the estate in equal shares. And of course, if it's only one child, then that child gets everything. If they're spouse and parents only, then 2/3 of the estates goes to the spouse and 1/3 to parents in equal shares if both are alive, both mom and dad are alive. Where their parents survive but no spouse, and those parents take the entire estate in equal shares. Or children, single surviving parent takes the estate. Absolutely. The class of persons next in line will take in equal share, and that's brothers and sisters of the whole blood, brothers and sisters of the half blood. So half brother, half sister, or I don't know if it's a full brother or full sister, but if no spouse and their children or parent, then the grandparents, uncles, and aunts of the whole blood, uncles and aunts of the half blood, and the crown then take the estate. Now, a lot of you may be looking at this table or listening to this recording and saying, but hold on, I wouldn't want my spouse to get 2/3 of my estate. I wouldn't want my parents to get any of my estate. I wouldn't want my child to get. And I want to say to you, if you want your estate to be distributed in a particular way, then put it in writing. I will say more estates are more complex than others, have more assets to distribute. It may be shares in a company, it may be, just a little more complicated. But for the most part, you do not necessarily need an attorney to write a will. Once it meets the requirements that I set out earlier, then your will may be considered valid if there's nothing else to invalidate it. So, what are you waiting for? Why not do it today? And if you're not sure and you want to make sure that you have all the things that are necessary to make your will valid, then you can speak to an attorney that will be able to provide you with guidance. All right. And so ask yourself, if I am no longer here, are my beneficiaries protected or are they exposed? If you are no longer here tomorrow, will persons know what to do, where things are, what you have? You need to put your affairs in order. And I'm making a plea. And again, a will is just one type or one way to plan your estate. There are many other ways, but at least in Jamaica, the Wills Act is clear. To make a will, you must be 18 years or older. You must be of sound mind. You must put your will and your wishes in writing. The will must be signed, and you must have two attesting witnesses who are not getting anything from the will. They're not benefiting, they're not beneficiaries under the will. But the cost of not doing it, the cost of not preparing your estates can be absolutely devastating. Take my word for it. I've seen it. A will protects what you have built. It protects who you love. It keeps the peace. It makes sure that your assets are distributed the way you want. The way you want. Take back your voice. It's one of the most powerful wealth tools you can have. I've never gone to a funeral and seen anybody take anything with them. So I ask you again, if you didn't wake up tomorrow, what would happen to what you have worked hard for? What you have worked so hard to build? Would there be order or chaos? Would there be clarity or confusion? Would the people that you love be protected or be left out in the cold? And just so you know, for those persons who are sort of superstitious, making a will doesn't mean that you're dying. We all are going to die. It means that you're choosing to lead. It means that you're choosing to lead even when you're not here. Well, it's almost, let me see, it's 11:15 and I think it's time for bed. But I wanted to get that off my chest. If this spoke to you, leave a like or a comment. If it made you think, this is your moment to build more than wealth. This is your moment to build peace, to build purpose, and to build protection. Follow us for more wealth and legal tips. Sign up to receive our newsletter, The Wealth Tribune, where wealth and law converge. And let's continue the conversation. I can't wait to speak to you again. See you soon.